I'll ask my first questions. In fact, I have a lot of questions of the legality that we can even do this, given that we're a general law city. I need to know, can a general law city stipulate a living wage if it's not in regards to contracts that it lets? Most of the living wage ordinances of the 130 that are across the nation, Santa Monica, San Francisco, City of Berkeley, just to name a few, all are ordinances that relate to the contracts that the city lets. And we have the ability, under the laws as they've been adjudicated to my knowledge, as I've looked over the many cases and the case law, just initially as a layperson, that they have all been held constitutional, and that those particular cases, like the city of Santa Barbara proposed Santa Barbara living wage ordinance, speaks to the city employees and employees of contractors and subcontractors who work on contracts and projects funded by the city. So I think that is probably meets constitutional muster. I think if you are discriminatory and specifically are speaking to a single entity, as this ordinance, as I read it, is drafted, it may not be constitutional, and that's just my feeling. And that's a layperson's interpretation, and I have the question to ask of our city attorney if she's looked at it and what her thoughts are.
Okay, so can I, let me say one thing first, and then hopefully everything I say will be prefaced by this, and I won't have to keep saying it. Because under the council rules, when a council member brings forward an item like this item, the rule is that it doesn't get any staff work, and the city attorney doesn't do a lot of work on this because we don't know whether the council majority would like us to work on this, and that goes for the city manager's office and for my office. So I've done some thinking about it, and I've done a little bit of investigation, but I have not done anything that would lead me to a final legal conclusion on the matter. Okay, so everything I say has that proviso. As you said, most of the living wage ordinances adopted by general law cities apply to city contracts. My office is currently defending the city of Emeryville in a living wage ordinance that applies to large hotels. And one of the issues in that case is whether or not general law cities can adopt that. I spoke to my partner this afternoon. He seems to believe that that they will win that issue. But again, I mean, that's in litigation right now, and I'm not aware that there's any definitive answer to that question. Generally speaking, looking at the larger context of everything, when the city of Davis or any general law city is looking to do a regulatory matter, something for the public health, safety, and welfare, we look at whether it's preempted by the state or federal law. But unless there's express preemption, most times the city will go forward, and then it's a matter for the courts to decide whether there's preemption or not. So, I mean, we obviously would give an opinion. We think it is. We think maybe it is, et cetera. In this case, I think maybe it's not. But I couldn't tell you that for sure.